without, just take Trump out of it just for a second. What is Kennan getting wrong about the material that's been seized?
Well, part of it is in terms of her authority to determine what that material is. It is in terms of defining what is classified information, what is national security information that should be restricted, that should be controlled. That's the purview of the President of the United States because he or she is commander-in-chief. And the Supreme Court has codified that. That's sort of a long-standing principle. And in her opinion, she challenges the representation of the Department of Justice. She says, ultimately, I don't know if I should trust this representation, and therefore we should provide this classified information to a special master and ultimately afford this judge the ability to determine what is classified. And that's just not the role of the judicial branch. That's not the role of this judge.
And I said take Trump out of it for a second because I think, like everything involving Trump, it muddles the whole. It muddles everything. But I think it's an important distinction. You're saying classified information belongs to the government that classified it. And whether Trump declassified certain things or not is irrelevant to what has been seized. Talk about the chain of custody now before it could even get back into the hands of the government.
Well, right now the government still has that information.
They can't use it.
But it can't. Well, it can't use it for its criminal investigation. And this is where the judge sort of split hairs and said for the national security assessment to determine what damage has been caused, it can be used. But the government's point is you cannot separate that from the criminal investigation. What the FBI is doing right now is essential to determining what damage may have occurred and how to mitigate it. They need to know who may have had access to that classified information. Where was it stored? That is essential because damage occurs if this classified information was someone had unauthorized access to it. And the more specificity they have, the better they can determine the damage, the better they can mitigate it. And right now, the government does not have the ability to make that determination.
When you were at DOJ, this case would have been something you would have been involved in?
That's right.
Have they argued this as plainly as you think they can? I mean, what is the best argument to make?
Well, I think the last two filings that the Department of Justice has made, it's elegant in terms of its tone and its substance. And what you have here is, even though we're talking about a special master, they have substantially narrowed the question here. And that's what made, to use your words, the decision last night astonishing. They have narrowed it and saying, even though we disagree with the imposition of a special master, it's unnecessary, it's unreasonable. Putting that aside, you cannot tell the executive branch, and by extension, the President of the United States, they cannot control access to classified information. Remember, the special master, the purpose of the special master is to determine, is there information that the Department of Justice and FBI should not have? For example, attorney-client information, sensitive information between attorney and his or her client.
Trump and Rudy, or Trump and whoever.
Even in you're taking away Trump from the conversation, so let's take Trump away from the conversation. The point is, there are communications between an attorney and his or her client the government should not have access to. And a special master is supposed to determine this information should not be provided. And that's what makes this decision so astonishing, which is it sets up the possibility that the special master and the judge could say, the Department of Justice and the executive branch cannot have access to this classified information. I mean, it's an untenable circumstance. And the reason we're there is because the Department of Justice had narrowed the scope of their request and put the judge in a situation to presumably not reach this decision. Mm-hmm. But it's the reason why I think we're going to see, an appeal, any minute now.
And what do you think will happen on appeal?
Well, I'm not near Katyal, so I don't want to take too many steps ahead. I think we will see the Department of Justice seeking an immediate emergency appeal as quickly as possible. And I think in doing so, we're probably going to continue to see a narrowing of the issue as opposed to challenging the principle of a special master being imposed. And they would have the right to do that, narrowing it to just the classified documents, just this limited principle, because I think it is, as members of the executive branch, it's just not tenable.
What's not tenable, I just want to make sure I understand, what's not tenable is a private citizen saying this, it's mine and you can't have it back, to proceed with the damage assessment or proceed with the case?
Well, I actually think...
I guess what I'm trying to understand is, why do you have Why do you have everyone, everyone from the left to the center to John Yoo and Bill Barr saying that Trump's case is garbage?
Well, and you're talking about a private citizen. I'm actually saying the judicial branch is not in a position, should not be in a position to tell the executive branch and the president how to control access to classified information. That is the purview of the executive branch. And again, that's the reason why the Department of Justice has no option but to appeal this, because there are principles here that go far beyond what is happening in this case. And so I think you're going to see a very vigorous defense of preserving the executive branch's ability to protect and classify information.
That's interesting. That's the first sort of window into understanding why you have the far right legal minds like John Yoo and Bill Barr making the same argument that some on the left are. Is that the principle?
Well, you know, what's remarkable is, like, there is no right and left here. This is not legal principles that are in dispute. I mean, there's a famous case from the 1980s where the Supreme Court explained all of this, and for years, for decades, including filings I did, everyone just cites to this one case because it has to be true. And I'll sort of make a further extension. There's a piece in the opinion where the judge challenges the representation of the Department of Justice when the Department of Justice says that it would cause irreparable harm to be compelled to disclose this classified information to the special master because it's highly classified.
Right.
And the executive branch knows what is classified. They know. The judge and the special master has no window into that, has no background. It has to be that the executive branch can determine what is sensitive and what can be disclosed. And the judge says that position is meritless.
How did we get here? How did Trump end up before the one judge that sees this very black and white, as you just said, nonpartisan, non-political issue about access to classified information in such a Trump-friendly manner?
It is not uncommon for litigants to try to find favorable courts and for the Department of Justice to charge cases in favorable courts. I think more so than even determining how, like, was this strategically done and how, it's more like we are at a point right now where there are really serious concerns in terms of the separation of powers. There were really serious concerns about national security based on this opinion. And so it doesn't matter who said it. It doesn't matter who appointed that. The Department of Justice and by extension, all of us who need this investigation to be conducted thoroughly and completely and quickly, this opinion, this order, this limitation, it just cannot continue. It has to be appealed and overturned.
Let's pull Trump back into the conversation. What does it say? I mean, obviously, if you're still in the department and if you were working on this case, you couldn't weigh in on this, but sort of informed analysis, what is your sense of Trump's endgame? He just wants to hang on to classified stuff indefinitely to show it to his friends?
You know, I don't think the Department of Justice right now is even focusing on the end game, because in terms of the national security issue, it doesn't matter. What matters is that for 19 months, hundreds of documents of some of the most highly classified and sensitive information have been unsecured and unmonitored and uncontrolled. That in and of itself is a significant national security issue, even if the motivation was sloppy record keeping, even if it is the most generous.
So you're saying take conversations about motive and endgame out. The crime or the alleged crimes have already taken place.
Whether they're crimes or not, from a national security perspective, it is, while it's relevant, even regardless of what those motives are, it is significant and it is serious. And the charges that are being contemplated, completely irrelevant what the motive is. It is in terms of the Espionage Act, it is the retention. Solely the retention of that information that is unlawful. There's nothing. There are laws that make it unlawful to disclose and transmit. That the Department of Justice has not indicated that that's within the purview of this investigation at this time.
They've sent a lot of I don't know if tea leaves is the right way to describe what the department does. It doesn't write in tea leaves, but there's a lot of public-facing evidence about obstruction. How would you evaluate what's in the public sphere about the obstruction?
Well, the obstruction is inextricably linked to the fact that right now we have this criminal investigation. I mean, it's important to continue to take a step back. The former president of the United States had classified information for over a year, then turned it over to the archives. And even though we know now that the FBI, there was a referral made in the open investigation, I don't think we would be talking about this if all of the classified information was simply provided to the Department of Justice then. And then in June, the Department of Justice goes down to Mar-a-Lago, has a subpoena, and collects additional classified information. If all of the classified information was provided at that time, I don't think we would be talking about criminal charges. We would not be having this discussion. But something happened, and that's where the obstruction comes into play. There were representations made to these attorneys and these agents from the Department of Justice. Their mission, they are tasked to protect classified information. This is what they do. And the obstructive element, it wasn't just obstructing an investigation, but it was obstructing an investigation to ensure that classified information that could damage national security was obtained and any damage rectified. That's the obstructive act. And so it really elevates, I think, the concern and really the level of seriousness of the conduct we're talking about.
When you look at the public-facing evidence of obstruction, do you see things that a normal person wouldn't? I mean, do you see that there's somebody cooperating that had access to this mishandling of classified documents? Do you see that there's a flow of information to DOJ?
Well, look, I wish I could say I knew what, redacted paragraph 65 referred to.
Me too.
I think more to the point, I think what it shows that there are certainly key people who are, in fact, cooperating, key witnesses who are participating. And I think when you talk about sort of the end game, what this looks like, really the ultimate question is going to be who with direct knowledge of what happened to this information, who handled the information, who directed that certain information be provided to the archives in the department, and who didn't. If those individuals have, with that knowledge, cooperate and participate, that's when you would see criminal charges.